there on the stage. I want to, and I have a talk prepared here that I'm going to give you, but I want to just say a little bit more about my background, and at risk of saying some things, that the two things that I just want to emphasize, that, and one of them I'm a little reluctant to, but I want to say because I think this may trigger some questions. I have done a lot of work at the United States Supreme Court, not only arguing myself, but helping other people. So about any major case that the religious right was involved in the last 20 years, I can probably tell you something about it. I helped the people on the Pledge of Allegiance case, the Ten Commandments, Rosenberger, Good News Club, Lamb's Chapel. I was one of the trial attorneys at Lamb's Chapel. On and on and on. So I did, and I'm not going to, that's possible. And in my work at the Supreme Court, I got to meet this, back in 1989, this obscure lawyer from the Justice Department named John Roberts, who became friends. And you can ask me about him, who I have high regard. Whatever you think of his philosophy, he's one of the smartest, best qualified guys for the Supreme Court. And he is definitely not a hack. And so I asked him after he'd been on the Supreme Court for, he started like in October, and I saw him in the summer, and I said, what's it like, I said, can you go, to the grocery store, and stuff like that. And so he related to me this one story where he said they were having a sale on shirts at Nordstrom's, and one of the ones in the D.C. area. So he went there, and he gave the clerk his credit card, or the salesperson said, John Roberts, do you ever dream one day that you might be that guy that was on the Supreme Court? And he said, no, never dreamed about that. So it never occurred that maybe this was John Roberts. And it is in D.C. You'll go to Costco and you'll see, senators, and I saw James Carville once buying diapers at Costco for his kids with Mary Matlin and all that. So anyway, the other thing that I wanted to tell you, which, I have been, involved in all these very ideological cases, but one that I have always had some reluctance or kind of mixed feelings about, although I have some strong, is that 6 months back in 1984, I was working for Concerned Women for America. 6 months after I started work, I was drafted as one of the staff, one of the lower level attorneys. There were 4 of us to work on, which I don't know, maybe they don't even know what this case is anymore. The Tennessee textbook case in Hawkins County, Tennessee. We had this big law firm brought in by People for the American Way, where we were asking to opt out of, we had representing some families that were objecting to various, occultic and humanism and all this stuff that was in the textbooks, the reading textbooks. And we won at the trial court. We lost at the Court of Appeals, and the Supreme Court didn't take it. But in the second half of the 1980s, this was a big, big case. And if you want to ask me about it, I'd be happy to. And I think that there's a lot of complexity to it that I don't even say. But I'll tell you one thing that I'll start off with and say in that case, and this is my opinion on this. And I grew up in Minnesota. I grew up in a nominal Lutheran home. I did not grow up in some strongly religious home. Many of these school situations, especially the one in Hawkins County, Tennessee, gets aggravated by groups like People for the American Way. Not so much the groups, but the attitude that they never can accept the fact that these people might have sincerely held, honestly come by beliefs and objections. They're always part of a plan by the TV evangelists who are manipulating them to take control of America and impose Sharia, Christian Sharia law, Taliban, all this sort of stuff. And it becomes almost kind of obsessive and ghoulish, the way that people like me are represented as sort of these like non-humans or something like this. And there's even though there can be intense and emotional disagreement, it's like they can never accept the fact that they are that these are genuine beliefs that have been come to by some honest process of thought, and not, like we're all dummies or something like that. And so I don't know if anybody here holds that belief, but I feel like people for the American way, I would talk to some of them and I say, look, I went to Stanford. I didn't go to Bob Jones. You know what? And I think some of these objections people have are legitimate. And why can't you be reasonable and acknowledge that rather than just like make it sound like we're just this threat that needs to be eradicated? So anyway, I think that attitude in that case really made it much worse than it could have been. In fact, well, I could go on and on, but I think there were ways to resolve it. That in fact there were two major attempts that we almost resolved it. But people for the American way kind of really stepped in and torpedoed things there. But anyway, okay. I want to talk today about, which I hope will be helpful and will spur some comments, 7 things the Establishment Clause does not require. And I hope that these are not like, my dream, if I could wave a magic wand exactly the way that I would do it. I think that this is common ground stuff, even though there are some court decisions that would disagree with a few of these. But I feel that there are court decisions that agree with every one of these that I'm putting. I think some of them are a little more common sense and maybe there's more room for agreement. But I think that, and these will not resolve every dispute that's out there. And but I think that a lot of disputes about religion in the public schools would be eliminated if these 7 things were adhered to. And I think that these are erroneous concepts that people believe the Establishment Clause requires them to do, and it doesn't. Okay, the first one. The Establishment Clause does not require the government to censor private religious expression. And there seems to be no distinction between whether it's government-sponsored religious expression or private religious expression. Sandra Day O'Connor wrote in 1990, there is a crucial difference between government speech endorsing religion, which the Establishment Clause forbids, and private speech endorsing religion, which the Free Speech and Free Exercise Clauses protect. That was in the Mergens case. And I find that this principle, this nuance, is lost on a lot of people. And the reason is they don't see this distinction. I mean, even separation of church and state, which isn't in the Constitution, understands this. Because in order to have, you have to have the state and the church to be separated. If you don't have the state, if it's private speakers, there is no issue there. It's a free speech issue, and you allow the private speakers to speak. There's no Establishment Clause issue, that is. And in fact, this is, I will tell you one fact about constitutional law, that if you know this, you will know more than about 90% of the attorneys in America on the Constitution. Although they learned this probably in law school but forgot it. And that is this: only the government can violate the Constitution. So if we can break the speed limit, but we can't break the Constitution. There's no provision of it. Perhaps, arguably, the 13th Amendment, if we owned a slave, we would violate that provision. But beyond that, we can't do it. So somebody getting up and saying, I want to quote the Bible at a public school, for example, is not violating the Constitution. I mean, there's contextual issues, but a private speaker is not necessarily a government-endorsed speaker. Now, the problems come because I think this is the violation of the second principle. So there's a difference. There's no constitutional requirement to eliminate private religious speech. And it's because of this error, which the Establishment Clause does not require the government to treat religion, especially Christianity, as a hazardous waste that must be eliminated from public life. So what instead of saying, is this private or public, what they ask is it religious? And then they treat it like if we were talking about asbestos in the ceiling tiles of a public school. Well, is it asbestos or not? If it is, we can't have the kids in the classroom. Is that a vial of anthrax there in the classroom? Well, if it is, we can't have the kids in there. And they treat religion that way. Is it religious or is it not religious is the way that they approach it. And that's not, context is everything. And if it's private speakers who cannot be attributed as state governmental speakers, there's absolutely no issue about the Establishment Clause. Now, to kind of illustrate this mindset, I want to talk about just briefly, a quote from a decision that the Federal Appeals Court in New York did in 1980. This was a case called the Brandon case about whether high school students could form together voluntarily to have a Bible study. Now, that right has been established since 1980 by the Equal Access Act in Herman's case. But listen to this. This is a quintessential example of religion as hazardous waste mindset. The court said the kids couldn't meet on their own, off in a back room for a Bible study. Our nation's elementary and secondary schools play a unique role in transmitting basic and fundamental values to our youth. To an impressionable student, even the mere appearance of secular involvement in religious activities might indicate that the state has placed its imprimatur on a particular religious creed. This symbolic inference is too dangerous to permit. Now, boy, that's hazardous waste. We can't do that. So now, like, for example, I think that this hazardous waste approach is, even if you don't agree with this, with some of these examples, I want to show you that context makes a huge difference on whether we're talking about private speakers or governmental speakers. So in the Pledge of Allegiance case, one nation under God, the way the hazardous waste folks approach it is God, trap door opens and it can't be said in a public school. That's Michael Newdow's approach. But one nation under God, I think, can reasonably be argued to be a statement of political philosophy and not a statement of religion. So, like, for example, let me illustrate it this way. If you have a founding father talking to Karl Marx, and Karl Marx says, I believe the rights of people derive from the dictatorship of the proletariat. Where do you think they come from, Thomas Jefferson? Well, I believe that we are endowed by our Creator by certain inalienable rights, being, on and on, quoting the Declaration of Independence. So one nation under God, to me, arguably, is not a statement of religion or devotion or something like that, but a statement of where we think our rights come from. Now, if somebody says, well, I don't agree with that, or I think it's a lie, and America doesn't produce its rights and all that sort of thing, I think they have the right to opt out. But to use this Establishment Clause sledgehammer and say, willing students and willing teachers can never say this because we think it violates the Establishment Clause is overkill and views religion as hazardous waste. It mentions God, trapdoor opens because it's a hazardous waste. And I think that is totally incorrect. Christmas carols being censored. That when people object to it and they say, this is talking about God and all this sort of thing. Now, I had a Christmas carol case in Grand Rapids, Michigan, where they were having a holiday concert and they had some Jewish songs, they had some religious Christmas carols and some Frosty the Snowman non-religious Christmas songs. And there was one by Amy Grant, I can't remember what the song was, and some student objected to it, and they were going through and censoring the lyrics in it. And we did some investigation. We did not end up filing a lawsuit, but we found out that the student who was so adamant about objecting to this had been in the choir last spring, and at their spring concert, they had sung all these spirituals that the black slaves had sung, and had no problem with that. And so we asked her, well, why didn't? Look at the intensity of the Jesus and Bible talk and these lyrics of these black slave spirituals, and that's just the way they were back then, and we were, she had this historical understanding of this. And so I said, well, look, I think that that's straining the gnat and swallowing the camel. And then I realized those were the words of Jesus, and that if that was brought up in a public school, you could explain that to the students by even actually reading the text of the Bible from them. It comes from Matthew 25:24. And if you're reading a book, and somebody says, well, that's straining the gnat or swallowing the camel, the student says, where does that come from? Well, it comes from here. Woe to you, scribes and Pharisees, hypocrites, for you pay tithe of mint and anise and cumin, and have neglected the weightier matters of the law, justice and mercy and faith. That's what you should have done without leaving the others undone. Blind guides who strain out the neck and swallow a camel. So here you are actually reading the Bible in a public school, and this would be eminently defensible because it's not being done in a devotional way, it's not being done in a reverence, ritualistic way, it's being done to explain what's going on. Now, this has probably all been brought up, but those who believe in religion as hazardous waste, they say, oh, you're quoting the Bible? That's wrong. That's like a vial of anthrax. We pull the constitutional trapdoor and it drops through. And I think that that's just kind of a mindless and unthinking way. And you can't teach music, you can't teach art, all of that. A lot of literature, if that's the approach that's going to be taken. Another view of the where there's no distinction between the private and the government, which I think is the more important distinction, rather than is this inherently religious, is these cases that come up where a public school will rent its facilities on the weekends when no kids are there, to every community group imaginable, but not for a church conducting a worship service. Because even though it's private speech, there's 100 different users from every group imaginable. They say, look how intensely religious the worship service is. This is religion as hazardous waste. The trapdoor must open. And I think that the Establishment Clause does not require that at all. So the Establishment Clause does not require the government to censor private religious speech. It does not require religion to be treated as inherent or intrinsic hazardous waste that must be expelled from public life. Third, the Establishment Clause does not require censorship of religious expression because it confuses others that there might be government endorsement. Or in other words, that people might think it's government-endorsed speech, like especially impressionable people. The Establishment Clause does not require that censorship. The Supreme Court said in the Milford, Good News Club versus Milford, we decline to employ the Establishment Clause jurisprudence using a modified heckler's veto in which a group's religious activity can be prescribed on the basis of what the youngest members of the audience might misperceive. So what you do is you explain to the kids that what the government permits, it doesn't necessarily endorse. So like, for example, in many of these forum cases, I've been trying to think of, and I've come up with one I think that will be helpful, an example of what would be the kind of speech that a public school would have to allow on a weekend if it allowed everybody in the community, but it would not want to be at all connected with, associated with, but it had nothing to do with religion. And I can think of one, because many of these policies will say things like, community groups can meet if it's cultural, educational, or pertaining to the welfare of the community. So they're very broad. Well, what if there was a guy, kind of out of the, well, I don't know, kind of with a very different opinion, medical doctor who believed that it was really dangerous and wrong to vaccinate children for childhood diseases. And he had this big PowerPoint presentation about how you get autism and this and that, other disease with it and all that. And he rented a public high school. Now he would be pertaining to the welfare of the community. People might come and do it, but obviously a public school would totally disagree with the point of view of having kids not inoculated with whooping cough and measles showing up for school. It would be disastrous. But there is no way that they could exclude that guy, say, people might think this is the school's position and that we support not giving vaccinations to your kids. And I think that that's the thing, that you've got to educate people that what the government endorses, what the government permits, it doesn't necessarily endorse. Now, the Federal Appeals Court in Cincinnati said this impressionable, we can censor religion because people might be confused and think that it's government-sponsored. They said they rejected that and called it the ignoramus's veto. We believe that the plaintiff's argument presents a new threat to religious speech in the concept of the ignoramus's veto. The ignoramus's veto, which is a takeoff from the heckler's veto, lies in the hands of those determined to see an endorsement of religion, even though a reasonable person and any minimally informed person knows that no endorsement is intended or conveyed by adherence to a traditional public form doctrine. The plaintiffs posit a reasonable observer who knows nothing about the nature of the exhibit. He simply sees a religious object in a prominent place public place, and it ignorantly assumes that the government is endorsing it. We refuse to rest important constitutional doctrines on such unrealistic fictions. So protecting impressionable youth does not, the Establishment Clause does not require the government to censor private religious speech simply because impressionable youth might be confused. Fourth, the Establishment Clause does not require the government to suppress religious speech because it is offensive to others. And this is, now I think that there's a lot of religious talk, as there is a lot of political or secular talk, that people can find very offensive. If somebody says, George Bush is a war criminal and we should elect Hillary as president, or says, marriage is a man and a woman, or says, Jesus Christ is the only way to salvation, a lot of people could react very negatively to those. And some of those are religious and some of those are not. But the Supreme Court has said that the negative reaction of hearers does not justify censorship. In one case, of many examples I could read where the Supreme Court has rejected the heckler's veto. But the fact that society may find speech offensive is not a sufficient reason for suppressing it. Indeed, if it's the speaker's opinion that gives offense, the consequence is a reason for according it constitutional protection. For it is a central tenet of the First Amendment that the government must remain neutral in the marketplace of ideas. Okay, well now, Jordan, you might say, that covers a situation where we can't censor a private speaker because I'm offended by what that person says. But what if it's the government that's saying the offensive thing? What if the government has a Ten Commandments or a Christmas creche or something like that? Now, I will tell you that some courts have allowed offended observers to come into court, but I think merely being offended by something the government says, the Supreme Court, at least on a couple of occasions, has said is insufficient. But I have to admit that they have allowed offended observers. Now, for example, in the Kentucky Ten Commandments case decided a few years ago, the ACLU brought that case, and they said, we have members who live in Kentucky who go to a courthouse, they have the Ten Commandments hanging on the wall of a county courthouse, to transact civil business such as obtaining and renewing licenses, registering property, paying local taxes, and registering to vote. And when they walk by and view the Ten Commandments, this is what the complaint, the document to start the lawsuit, the ACLU said, quote, each plaintiff perceives this Ten Commandments display as a violation of the Constitution. Each plaintiff is therefore offended by the continuing display. Now, if I was in that courthouse, that county office, I would be more offended by the sign that says pay taxes here. But that's a different story. And I think that merely seeing something, and this is, I want to get to this and then talk about some of the law for a moment. I think that many of these cases are aggravated by this kind of cultural norm, I don't quite know, that sort of gets communicated that if somebody says something religious that you don't like, you are allowed to have eggshell sensitivities and really react to it. Now, if the government says, support our troops in Iraq, or just say no to drugs, or justice and liberty for all, you can complain about it, but you can't censor them. I mean, that there's not even people having the same kind of eggshell sensitivities to that sort of thing. Justice O'Connor wrote in the Pledge of Allegiance case that, of course, people can opt out from saying the Pledge of Allegiance, but she said, the Constitution does not guarantee citizens a right entirely to avoid ideas with which they disagree, when said by the government. No robust democracy insulates its citizens from views that they might find novel or even inflammatory. So I think there's got to be more than somebody just being merely offended in the abstract by the expression of ideas before they can come to court and claim that something violates the Establishment Clause. So just for review, I said the Establishment Clause does not require the government to censor private religious expression. It does not require the government to treat religion as hazardous waste and needs to be expunged from public life. The Establishment Clause does not require censorship of religious expression because impressionable youth might be confused. Fourth, the Establishment Clause does not require the government to suppress religious speech because it is offensive to others. And then, fifth, the Establishment Clause does not require exclusion of religious groups from public benefits because of an alleged subsidy to religion. Now, this usually comes up in the context, and I'm not talking about voucher cases or charitable choice, but this argument has oddly come up in situations where it's usually public schools say, here's our building, it's open on nights and weekends, and anybody can come in here. And they'll have like 100 community groups meeting there. Yet they will say the churches can't meet because it is a subsidy of religion. The Alliance Defensemen had a case which we lost at the Ninth Circuit, and the Supreme Court unfortunately turned us down last Monday. And it was against Contra Costa County Library, the Faith Center case, where a woman preacher from Sacramento wanted to hold 2 meetings at a library meeting room. They said no, because of worship service. The Ninth Circuit agreed with them, unfortunately. And cert was denied on Monday by the Supreme Court. And a Contra Costa attorney said, quote, allowing worship services in the public libraries would amount to having taxpayers subsidize religious expression. Well, I would like to ask that attorney that our records, and their records showed, that they allowed the local Democratic Party to meet in the very same meeting room to select candidates to support. So was that an in-kind campaign contribution by the county because they let them meet there? They also allowed the Sierra Club to meet, and the purpose of the meeting was to select legislation to support and like to get their targeted goals for the next legislative session. We're going to support these bills, we're going to oppose these bills. So was this also an in-kind contribution for lobbying to the Sierra Club? Now I think you can see the problem. There's no subsidy to religion if it's a subsidy that everybody gets. That it's like saying the Social Security system violates the Establishment Clause because we found a group of old people that contribute to their houses of worship out of their Social Security checks. That it's the people choosing to avail themselves of this opportunity. It is not a government subsidy for religion if the local Jewish synagogue, when it's constructed, hooks up with the city sewer system. Hey, they didn't have to build their own sewer system, so that's a government subsidy to the Jewish synagogue. Or if the local Buddhist monastery catches on fire and the fire department comes and puts it out, that's not a subsidy to Buddhism because they didn't have to contract for their own private, their own fire service or something like that. So this whole argument about government subsidy can't be, I think it's got to be targeted to just religious groups or something like that. But the fact that general benefits that the government provides to everybody, like meeting in a building and some of these other things, can't be viewed as subsidies, it just makes the whole categories of discussion impossible because it's so debased and watered down. 6, the Establishment Clause does not require the government to treat Christianity worse than other religions because it is a majority religion. Or another way that this is stated is that, I'm putting this somewhat tongue-in-cheek, only Christianity is religious, all other religions are only cultural. So here's a couple of examples of that. In the Rosenberger case, which involved student fee money being used to fund student publications, the University of Virginia refused to fund an evangelical Christian newspaper. But when it was pointed out to them that they were funding a Jewish students' organization's newsletter and a Muslim student organization's newsletter that were full of quotes and discourse on the Torah and the Quran, the response to the University of Virginia officials were, well, those are cultural groups. They are minority religions, and that's part of their culture, but evangelical Christianity is sort of like religion, and it's the majority thing, and so that's different, and we can exclude that. The Supreme Court ruled against the University of Virginia in 1995. I had a case called Roberts versus Madigan in Colorado, where a reading teacher, 5th grade students, had the way that he would conduct reading is he would teach things, and then he had a silent reading time. And if students hadn't brought books from home, He had a bookshelf of about 350 books that he just sort of accumulated any which way. And he had two books that one parent objected to, The Life of Jesus and the Bible in Pictures. Now he was a great student of Native American religions and had many, many books about Native American religion and also on Buddhism. And he would also read silently. He read The Life of Buddha silently in the classroom, the model to the kids. He read many of his Native American religious books. And he also on occasion read the book of Proverbs out of the Bible. So when the judge was saying, well, look, I think you can't do this because of impressionable youth, we said, well, then why don't you remove all the religious books from this library that he has in the room, and also ban him from reading any religious book at all, the Buddhism books, the Indian books. And the judge said, no, he did not have to do that for this reason. We find that exposure to the tenets of a little-known religion, such as those followed in the American Indian culture, is far less influential on young students than exposure to a modern-day, widely observed religion, which is a recognizable part of our society. So again, it's, Christianity is religion, all other religions are only cultural. One of the other interesting cases was when the city of San Jose, California, about 10 years ago, erected a statue to Quetzalcoatl, the Aztec plumed serpent god. And I would not have supported the lawsuit, but some people that I know filed a lawsuit saying that it violated the Establishment Clause to use public funds to erect this statue to Quetzalcoatl. And they pointed to as obvious, this was a deity. You can imagine if they'd erected this statue to... And they also pointed out, well, look, Quetzalcoatl was a god, but then there was a later Aztec emperor who took his name and tried to stop the human sacrifice. So are we talking about the human Quetzalcoatl or the deity Quetzalcoatl? And they kind of got merged together in Aztec, and so maybe this wasn't that religious. Now, I just think, maybe that's okay, but just think if they'd erected a statue to Jesus Christ and said, he was fully man and fully God, and we're honoring him as a great teacher. I just don't think the ACLU and its allies would have bought that for 2 seconds. Now, and then again, I just think that this is kind of interesting when I hear about this. They had one woman who was on the city council, got up and was expressing, she was Hispanic, and about how this was part of her Hispanic heritage, and it just brought her to tears to see this Aztec cultural thing. And it was like a spiritually moving event for her. And they said, well, see, they're kind of worshiping Quetzalcoatl. So the court said, plaintiffs also cite the speech given by, given by Luis Valdez at the unveiling ceremony and the statements of Councilmember Blanca Alvarado, attesting to her own spiritual response to the piece and sharing her impressions of Aztec culture. Review of these statements reveals that they were made not in a religious spirit, but in homage to the city's Mexican heritage and to the contribution of indigenous peoples to Mexican culture. It is commonplace that a work of art may affect someone on an emotional or spiritual level, or even move her to tears. This does not imbue the work with religious content. Now, what I think is interesting is that the context was very important. But if this has been a statue of Jesus, it's hazardous waste, the trapdoor's got to open. So I think that this is an example of, I don't necessarily mind. I just think that this is interesting. But the Establishment Clause does not have this double standard where Christianity is religious and all other religions are merely cultural. And then I just want to wrap up with this, and I can take questions or whatever. 7, the Establishment Clause does not require a court to invalidate a law when the lawmakers enact them with religious motives. Now, the Supreme Court has spoken to this and has, at least in one case, invalidated things when they said that there was a religious motive. This is usually how the argument comes up. It's usually there's some public policy law that's being pushed by conservative Christians or traditionalists. And people go, oh, even though there's nothing about religious in this proposal, all these people are motivated by their Bible beliefs. So it probably violates the Establishment Clause. An example of this, a little over a year ago, the Washington Supreme Court upheld the marriage laws of Washington on a 5-4 vote and said it didn't violate any provision of the state constitution. One of the dissenting judges, Bobby Bridge, wrote and said that she thought that it violated the Establishment Clause to have a marriage law that defined marriage as one man and one woman. What we have done is permit the religious and moral strains of the Defense of Marriage Act to justify the state's intrusion. As succinctly put by the friend of the court brief of the Libertarian Party of Washington and the Log Cabin Republicans of Washington, quote, to ban gay civil marriage because some but not all religions disfavor it reflects an impermissible state religious establishment. After all, we permit civil divorce, though many religions prohibit it. Why such fierce protection of marriage at its beginning but not at its end? Now, I think there's a couple of responses to this. But the first one that I want to state is that where were these people a few months later when the Supreme Court heard the case of Commonwealth of Massachusetts versus the Environmental Protection Agency? Now, this is a case about whether the Clean Air Act requires the Environmental Protection Agency to regulate carbon dioxide as a pollutant creating global warming. And the Bush administration said they didn't have to do it, and there was this big lawsuit by the state of Massachusetts and others saying, no, you have to regulate, we've got global warming, you have to regulate carbon dioxide as a pollutant. And the Supreme Court, by a 5-4 vote, ended up saying that they had to do that later that year. But what I thought was very interesting, and I don't know how this all got missed, when things like, hey, this marriage law in Washington is probably passed by the religious people. The National Council of Churches submitted a friend of the court brief on how you should interpret the Federal Clean Air Act. And this is what they said, and I'm just quoting directly from their brief. Followers of the Judeo-Christian tradition are called to be responsible, just stewards of the earth and the abundant resources that it makes available today and for future generations. See Genesis 2:15 and Genesis 9:12. The National Council of Churches told us that the Environmental Protection Agency should regulate carbon dioxide emissions because, quote, Christian ethics preaches love of our fellow humans as ourselves. Matthew 22:39, Mark 12:31-33, and more particularly, care and compassion for those who are the most vulnerable in need. See, for example, Matthew 19:21-25. You get the idea. Now, I would have thought the ACLU, Americans for United, would have been all over this. And why was there not a friend of the court brief is that you can't regulate carbon dioxide, because if you do, you're establishing a religion, the religion's abuse of the National Council of Churches. I say that in tongue-in-cheek, but I think as a analytical tool, this whole thing of like, well, what were the motives of the people is totally useless and have anything to do with whether something violates the Establishment Clause. Because if somebody says, I'm voting for an increased payments of money to poor people or for health care for children because the Bible says we should take care of the needy, that doesn't invalidate it. If a state has an argument on whether they should have the death penalty for murder, and somebody says, I think we should because Romans 13 says the state does not wield the sword in vain and God had given it to them. Somebody says, no, but Jesus said we shouldn't have the death penalty because turn the other cheek. So you got people on both sides of the issue quoting the Bible. Then if you enact the death penalty or repeal the death penalty, you're establishing religion. People would bring this up to me when I would do debates in favor of state marriage amendments, defining marriage as a man and a woman. And I would usually be able to point out clergy who had their clerical collars on and say, I think that you probably oppose this amendment. Yes, they do. Okay, so if there's clergy that support the marriage amendment and clergy that oppose it, then how does an Establishment Clause analysis help you at all? I think you have to look and see what the law actually does. And if it doesn't establish religion, some religious practice, I think the motivations of the people that do it is just unhelpful. Was the Civil Rights Act back in the mid-'60s unconstitutional because Martin Luther King Jr. said that it was a good thing and purported to biblical justice to enact it into law? I think that's the idea here. So let me just review these quickly and then just make one concluding remark. 7 things the Establishment Clause does not require. It does not require the government to censor private religious expression. It does not require the government to treat religion as a hazardous waste that must be excluded in all contexts. The Establishment Clause does not require censorship of religious expression because impressionable youth might be confused and think it's government-sponsored. The Establishment Clause does not require the government to suppress religious speech because some are offended by it. The Establishment Clause does not require exclusion of religious groups from public benefits in all situations because it's an alleged subsidy to religion. The Establishment Clause does not require the government to treat Christianity worse than other religions because it's a majority religion, or Christianity is religion, but all other religions are merely cultural. And then last, the Establishment Clause does not require courts to invalidate laws when lawmakers enact them with religious motives. Now, I realize a lot of the things you've been talking about, this, I don't even touch on some of these curricular matters and all of that. Maybe we can talk about these in the panel or other. But one thing I think is clear and would eliminate a lot of things if we followed what Justice Brennan wrote back in 1978. The Establishment Clause does not license government to treat religion and those who teach or practice it simply by virtue of their status as such as subversive of American ideals and therefore subject to unique disabilities. Thank you very much.